Fantastic. Thanks so much. It's great to see you all. My name is Joanne Sprague. I have the pleasure of leading the social impact program at Everlaw. We call it Everlaw for Good, and it offers our product, which you'll hear a little bit more about, our e-discovery tools, free of charge to nonprofit organizations, pro bono practices, investigative journalists, and educators. But the real star of the show here is my colleague Cal, who I will let introduce himself, and he is the technical expert here. I will give a little bit more information on our program at the end of the call, but the purpose of this is obviously technology and AI in the practice of law. So I will pass it to Cal to introduce himself and take it away.
Yeah, hey everybody. Thanks for coming. So I'm a member of our Value AI team here at Everlaw, and my role is to help uh, our customers and different folks understand the nature of machine learning and generative AI tools. Prior to coming to Everlaw, I was a practicing attorney for 5 years at an AmLaw law firm. So lots of time in the seat is maybe the right way to put it. Um, and excited to talk about the intersection of legal ethics and generative AI here today. So with that, I guess let's get to it, right? So we're going to be talking about what e-discovery is, what the ethical considerations are related to that, and how we might look at adoption, change, and value, right? Um, Everything sort of stems with respect to the ethics from Model Rule 1.1, Comment 8. It's been widely adopted across the US at a state by state level. Um, this is your duty of technical competence, right? To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And this also applies for paralegals and um, other supporting team, right? And so there's a variety of rules that relate to this intersection. They all boil down to a few base premises here, right? Attorneys have a duty to supervise, and attorneys cannot pass off or abrogate their judgment, their legal judgment, right? And so to that, all of these rules really speak to that, supervising junior lawyers, supervising non-lawyers and vendors, um, using your judgment and your supervision over, for example, generative output, right? Making sure that you're providing that human in the loop assessment. Maintaining confidentiality is an interesting one to talk about recently. I don't know if anybody's noticed, but there's some conflicting holdings regarding whether putting your information into a generative AI chat interface, ChatGPT or similar, maintains confidentiality, right? So it's definitely an important topic of consideration here, and we can jump into the specific questions in the Q&A if you guys have them. But really, the high level takeaway from this slide is you cannot abrogate your judgment and you cannot abrogate your responsibility to supervise to the extent that you're not doing the work yourself. And this is consistent with state bar opinions across the US. It comes down to just showing that solid ethical judgment, right? Making sure that you are the person who is in the loop. You're the final arbiter of whether or not this constitutes defensible work product, right? Whether it's from a summer associate or whether it's from a generative AI tool. So just looking really specifically at California real quick, you also have to consider the local rules and holdings as well. There's a number of courts in California with standing orders related to AI usage, right? So any AI, generative AI, caution regarding the use of, right? You'll note that in California, none of the courts prohibit the use of AI, right? So this is really about responsibly and ethically practicing where this technology comes into play. So why are we talking about this, right? Why is this such an important topic? The lack of rendered judgment from legal teams has led to over 1,000 cases worldwide and 761 cases in the US as of yesterday, right? Where hallucinated content was submitted to the court. 70 of those cases were in California. So, we can get into the details there about that. The 61 cases is interesting because over, I can't remember the exact number right now, but I think it's over 450 of them were by pro se litigants as opposed to practicing attorneys, right? Um, so being sure that you are not a member of the 260, I think is a big part of the reason why we're here today. And really, as long as you're exercising the same kind of judgment that would prevent you from putting a first year associate's work submitted to the court without review, right? The same kind of criteria there applies, making sure you're using confidential and secure iterations of generative AI tools as opposed to public instances. Just using that reasonable judgment. So, it's not just, ChatGPT that we need to consider about here, right? Or another natural language conversation tool. There's also the advent and the rise of deepfakes and the democratization of the skills in order to create those deepfakes, right? It's very easy now for people to create this content. Uh, so we're looking here at a headline for an article where there was a finance worker who paid out $25 million after a video would call with a deep fake CFO. We all have an idea in our heads if I say deep fake video or Gen AI video of what that might look like, right? Unfortunately, that's actually kind of an outdated concept. It's now becoming harder and harder to tell the difference between generative content and wholly created content, right? One of the proposed solutions here is the institution of a new encryption standard called C2PA. And were that to be universally adopted, it would be really useful because part of what it adds is novel metadata elements, new pieces of a digital fingerprint that identify whether or not something is generative in nature or augmented by generative content. Uh, Problem is, until it's universally adopted, it's only going to be of limited value, right? So, you know, how do you, in your day to day, make a judgment call on content to ensure that you're not submitting perhaps deep fakes unknowingly to the court, right? Um, is it too good or too bad to be true? Does it pass the sniff test, right? Um, I like the framework that Maura Grossman and the rest of her team have put forwards regarding Federal Rule 707, right? Generating evidence is offered without an expert witness will be subject to Rule 702. If testified to by a witness, the court may admit the evidence only if it satisfies the requirements, right? Does it assist the trier of facts, sufficient foundation, reliable methodology, and reliable application? Treat it like expert witness evidence, right? And provide a framework for assessing the validity of the content. So before employing any technologies that filter potentially relevant data to or instead of human review, the parties shall meet and confer and discuss the technology and the filtering method, right? Like how do you approach a framework in a litigation where you don't box yourself in so narrowly in your use of generative AI that it stymies your ability to use the tools or opens you up to liability, while also putting the guardrails on with your opposing party to make sure that you guys are working from the same playing field, right? Um, when in past practice, what I've seen several people use is to say that the parties will utilize all available technology, including but not limited to email threading, technologically assisted review, generative AI, right? And then the parties will meet and confer regarding specifics as necessary. And that leaves you with a lot of latitude to be able to design a review protocol that allows you to take advantage of these new tools without tying yourself down so concretely that you're not really able to take full advantage of them. So, how do you remain ethical in this practice, and what are good bright line guideposts in this work, right? Um, Keeping transparency with your clients, with the court, and with the opposing party, making sure you maintain control over confidentiality and accuracy of work product by utilizing that human in the loop judgment, which you cannot abrogate to generative AI. And, that duty is supervised for reports, technology, process. I would also say application, right? Making sure that you understand either how these tools are being applied or you have someone on your team who does. So one of the largest areas of growth for the use of these tools is in alternative dispute resolution, right? Um, some of the rules and requirements regarding, trying fact in these alternative dispute resolutions lend themselves more readily to experimentation with new tools. Um, Turning to the litigation, like hard litigation aspect, uh, using these tools to say prioritize a human review or to prioritize a machine learning TAR-CAL review allows you to take advantage of their efficiencies while staying within a well understood framework for defensibility to courts. So, going from data overload, parsing signal and noise, right? You can utilize these new generative tools to very quickly find the needles in the haystack. So at Everlaw, we have a tool called Deep Dive, and it's think of it like a ChatGPT window, except it only answers questions with information from your documents, right? And so what we used to do yesterday was go over search terms and agree upon the color and the shape of a review, apply those search terms, start running through documents. You might find some of your key documents within a few weeks to a month, right? Now what you can do is as you start that process, because you still have the discovery burden and obligation to the court, you can ask for the needles right away and get the needles back to your question, right? The most up to 200 of the most relevant documents, get them pulled back and then from there, start working with that knowledge to shape your review. Uh, that allows you to spend more time in documents that are not just technically relevant to your case, but directly on point. And having that speed to insight can provide a strategic advantage in motion practice, right? Or maybe you need to settle right away. So moving on here, you can also utilize AI in first pass review. This is really going. This is the other part that discovery obligation and burden over the entirety of the course of materials, right? So, maybe it used to take 4 weeks to do a completely manual linear review. Now you can use less people, right? And less time to get to that discovery burden. You use the tool to do sort of a first pass on the review, and then you're exercising that human judgment on a QC or second level review, right? Going through the results instead of working from the blank page to a first draft of a contract. This is the doc review allegory of working from that first draft. And so, when considering any of these tools in application, what is important here? You have to make sure that the information is secure. That is how you can measure risk and manage that risk, right? There's a gradient scale of what constitutes risk here, and the more different tools under different licensing agreements that you're submitting your data and information to, the more risk and the more assessment you have to make, right? Um, Having good planning, operational planning as an organization from the outset, figuring out what are my tools going to be in my toolbox. Um, have I vetted all of those? Do I know what their security protocols are? Do I have somebody on my team who can help me do that? Right. And then after you figured out how you can responsibly introduce tools to your organization and the work that you do, which tools to add, right? How do you know whether or not it's worth taking the pain and effort of change management to introduce new tools? That requires a pilot period. That requires testing and comparison. Um, Once you have a tool and you have adopted a tool, then in the same way that you have a framework and an understanding as an organization about what security means, you need to do the same thing for what work means in these tools, right? Making a standard practice that you can leverage the efficiencies over and over again. And then once you have that process, you can ramp up as an organization, whether it's one or two or three people, right? Or whether or not you're talking about a department of 30. So, I mean, this is very much what we were talking about here, right? The rules-based permissions, zero data retention, certified security standards, not just for your organization, right? And not just for the particular technology that you're considering, but the server infrastructure for where that is sitting, right? Is it Amazon? Is it whoever else? Making sure that all the boxes are checked along the way, and you understand how secure the practice is. um, Being able to ground the output of these tools to the evidence in front of you, being able to limit the training of those tools being used to answer questions, and requiring citations to sources are all ways to check and mitigate that risk, right? And then making sure that you understand who in your organization is a stakeholder, who is the champion to sort of beta test and understand and conceptualize and organize how you're going to interact with these technologies. Working together as a team, I would encourage a multidisciplinary team where possible, right? Making sure you got somebody from IT, making sure that you got somebody from the actual legal practice, being able to work together to create that framework with which you can assess these tools. So, you start with a pilot case. That's how I started when I first started using these tools in past practice. You find a good candidate case that's not, say, too large, so it's easy to control for a variety of factors. Um, you make sure that you have someone who is able to engage and interested in engaging, and that you empower them to do so as the internal champion. And then you set specific and concrete criteria for what success looks like, right? Does success look like accurately reviewing all of the documents in the case? Does success look like being able to do so quicker and more efficiently as compared to manual review? If you're looking at knowledge management software, are you able to both easily use that software and also securely host your documents, right? Like, are you trading one for the other? So just understanding objectively what success looks like. Then once you do that, you can understand the outcomes and learnings, develop your best practices on that basis, and then expand that pilot to more matters. Then once you have an understanding of how the tools work and how they can help you, that's when you really create that workflow that embeds it as part of your standard practice to increase that efficiency, right? So once you understand it, once you've confirmed it, that's when you start implementing it at an organizational level. All right, so you have to understand where you're going. You have to be aware of what the pain and the problem is today. And you have to have an agreement amongst that team, hopefully an interdisciplinary team, of what success looks like and how you get there, right? Then you need to have those internal champions who are able to sort of move forwards. And then that is reinforced culturally throughout an entire group or organization. So, what success looks like, those objective criteria that we were talking about, it could be and should be a multifaceted assessment, right? But, we could be talking about margin on documents for profit. We could be talking about being able to scale to larger litigations in a not-for-profit situation, right? Um, Making sure that you have your expert being able to effectively be multiplied across the documents, as opposed to being precluded from being able to work on larger litigations. Um, I really can't emphasize enough the impact of time to first insight. Uh, Strategically and just organizationally, it does a lot for you, right? Whether you're talking about potential civil rights violations, an investigation into whether or not there was, harassment, any of these kinds of investigatory hunt and find situations, that time to first insight is key. Uh, Making sure that you are actually enabling and empowering your team to be more efficient and effective, as opposed to burdening them with yet another new tool to learn, right? So what does that look like when you're actually doing it? That's part of that design, is making sure you understand how what value these tools bring in context to the way that you guys do your work. So if you're going to take away anything from this, it's that AI is a competitive necessity, not a novelty, right? It should become standard practice to maintain and grow the market position. You can turn efficiency into strategic leverage. That's that time to first insight, more advanced strategic knowledge ahead of motion practice, for example. Um, this says protecting the firm's profitability. Apologies, but the same's true here on the pro bono side of things, right? Like this affords better access to justice using that strategic leverage, right? By multiplying out who can do how much. Um, and then you have to have well understood objectives for success, apply those objectives to test criteria to show whether or not this tool has value to you, right? And then from there, that starts the conversation and that starts the culture change that you have to actually implement these tools. All right, so I'm going to pause there for any questions everybody may have for me. We're going to look at the Q&A here. So if you have any questions, please shout them out. All right, everybody is an expert now. I love it. Has AI necessitated an explicit reference and guardrails in contracts with experts? Interesting question. So, just making sure I'm hearing what you're asking. I'm hearing you say, do you need to explicitly call out the use of generative AI in work with, say, expert witnesses? Um, I am not aware of that to date. The way I've seen these tools used the most effectively with respect to expert witnesses has been in um, for example, impeaching opposing expert witness testimony by searching live in court for documents that contradict, say, a damages assessment. Um, I've seen it used to allow for a more effective and natural language approach to answering targeted expert witness questions within certain sets of documents. So, all of that to say, as opposed to being a restrictive layer that filters what information an expert has access to. All you're doing is providing a new tool for them to get to those documents. And so by doing so, it's more of a organizational methodology as opposed to a new step in the process. I haven't seen the need to call that out yet. Um, we can follow up about model AI policies, right? Um, I agree with you, Sylvia, that what an expert witness does, a third party does, is not totally within a lawyer's control. Um, and, other than that excellent adage of you never want to ask a question you don't know the answer to. But um, so, part of that is having a tool that provides the documentation and the process as part of it. So, for example, we referenced this tool Deep Dive before, right? Where you can ask those natural language questions in a secure platform, get the answers back. One of the things that also does for you is it records all of the questions the way they were asked, which documents were returned, which documents were used to answer the question. All of that is documented and maintained in the history of that tool. And it's easy to create, say, a timeline or a report of that information should you feel the need to submit that to the court, right? Again, I can't control what an expert witness would search for. I also can't control what an expert witness would find of value in their assessment, right? So I see it more as a way to get to that as opposed to something that you need to submit to the court, but reasonable minds may differ there. All right. If anybody has any other questions they think of following this CLE, always happy to answer via email. We can make that available to you guys. Uh, Thank you.
We also have a question in the chat. I can read it off. Are there percentages of documents courts have agreed are acceptable on responsive/non-responsive that need eyes on in order to validate the quality of AI?
Really interesting question that is still up in the air. So reframing your question just a little bit so we can talk about the all the angles, right? Uh, Prior to generative AI, we used machine learning in the form of technologically assisted review or continuous active learning, TAR and CAL, to create models to identify documents that are relevant to the case. They would give you a 0 to 100 score for how relevant that document is to the nature of your case based on the training. Those models are assessed with precision, recall, and a combination of those two called an F1 score, right? You also need to do illusion sampling, so testing, looking for things that are relevant that were missed, right? And those are the metrics that you use to submit whether or not a model is effective and defensible to the court. What those numbers are a judgment decision made by the team, right? So in past practice, recall has generally been minimally acceptable, somewhere between zero point 0.7, right? So like say 0.68 to 0.75. Um, Preferably, these models have a recall over zero point 0.8, so an 80% recall. Um, Now, I mention all of that to say one time in which you did not need to submit that data to the court is if you were using a predictive coding model in order to prioritize and not cut off your review, right? So you were using a way to organize the data from most relevant to least relevant so that a human could review and assess that data. If you have somebody who's passing 100% of those documents, that's a human review, right? Now, in my opinion, you should absolutely be doing that precision and recall assessment over human review, search terms, any and everything to produce documents. But the reality is, that's not the standard, right? The standard is over the machine learning. Which brings us back around to the generative AI. For my money, the generative AI is a really efficient tool to help you categorize and prioritize documents for human assessment, being that human in the loop by passing a second review over all relevant documents, looking through the non-relevant documents, right? By prioritizing that and by having a more efficient second pass at a human level and exercising and rendering your ethical judgment, you're able to submit to the court on that basis. I'm unaware of today anybody who has submitted solely based on generative AI. Can I explain a little bit more about how AI works with respect to creating search terms? Interesting. Um, so I didn't actually explicitly call out using AI to create search terms, but you can absolutely do that. So ways I have used that in past practice have included taking an RFP, request for production, and then the response to that RFP denying or modifying the scope of production, right? And then creating a new standard that's a synthesis of both of those, and then having the model extrapolate out potentially relevant search terms for each of those RFPs. I would call that a starting point, right? Like it did all right to pull out some potential search terms based off of what was being requested. And then I had to exercise and render my human judgment, modify those search terms, add things that were missing. But I wasn't operating off of a blank page, right? Uh, Most effective when you have more RFPs. I had a case with 168 RFPs that I did this on, and it allowed me to take this from something that was not doable in the timeline provided to a successful resolution before the timeline. All right. I think we're going to call the questions there. And then, Joanne, I think we're going to move on to you for now.
Great, thanks, Cal. Hopefully this was useful to y'all and provided some additional continued learning on this. Obviously, AI is a fast-moving field. Things are changing daily, weekly. There's a lot of movement. Also, I think that the regulatory space is struggling to keep up. And so we'll continue to see evolution. We'll continue to see these statistics change. It's definitely worth keeping an eye on this space. I'm really glad that you are all here working on that. For Everlaw, and our social impact program, it's really important to us, especially in this fast-moving era, to help level the playing field for justice, and especially with you all to ensure that the rise of all these new highly advanced AI and generative AI tools can help to be a force to narrow rather than widen the justice gap. We're seeing law firms, in-house counsels, government agencies, corporations really digging into this stuff, really investing in AI adoption. And we're also seeing that among legal services organizations and nonprofits and pro bono matters. And we just want to do what we can to ensure that uh, legal services organizations are getting access to the most effective advanced technology so that, in litigation, they can sit on an equal playing field and have the greatest access to tools to fight the cases that are extremely important. So that is why we have our Everlaw for Good program, which is really focused on reducing both the financial and operational barriers to legal assistance for people who can't afford to pay many, many dollars an hour for an attorney, and to help legal aid professionals to make their cases more efficient, more effective, find those needles in the haystack that can help you serve your clients even better over time. So that's a little bit about why we are doing this work and why we were so excited to partner with the Legal Aid Association of California on this CLE. Cal, if you want to go to the next slide. Just a little bit about our program. So we've been around since 2017. We've had more than 300 participating organizations, including more than 50 legal aid organizations. We are based in Oakland, California. So we have a little bit of a bias towards California organizations. So I have a number of you all. I saw some friends and partners on the participant list. So excited to see you all here. We've supported more than 800 matters on the platform to date and donated more than $6 million worth of product. That's the volume or the amount that it would have cost if we had charged for data stored on our platform instead of offering it at free and discounted rates. And then you can go to the next slide, Cal. This is just a little bit of a sample of the types of organizations that are in our program, including many NLAAC members. So some of you, I know CLA SoCal is here. I believe Legal Aid at Work, I saw someone. So really excited to have you all as part of the program. And this is just a small sampling. Cal is actually a former Everlaw for Good customer back at his law firm before he came and joined us. So this gives you a sense of the types of organizations that we work with and strive to support. And then Cal, you can go to the next slide. So if anyone is interested in our program and getting access to free AI-enabled e-discovery software, our program offers full access to Everlaw free of charge up to a data cap with 80 to 90% discounts for larger matters. The data cap is generous enough that about 85% of our program participants never end up seeing a bill or getting a discounted rate. And then above that, any charges that we do provide for very large matters help to subsidize the rest of the program. And that program benefits include, full access to the platform. It's not a smaller version of the platform. It's all features and capabilities. We offer unlimited licenses, so there's no fee per seat or no cap on the number of seats for folks within and outside organizations that come and work with us. An unlimited number of databases, and our data cap resets for every new database or matter you would open on the platform, and an unlimited time frame because we know that these cases can last, years and decades at times. We also have a world-class award-winning customer support team, as well as a user education team that provides both live and on-demand trainings on all aspects of the platform, as well as continuing education like Cal has provided today. And that's all provided unlimited at no extra cost. And then most of our generative AI features, which are an optional addition to the platform or offered free of charge. But we do have some the very burdensome, sort of heavier token AI capabilities, like I think Cal mentioned Deep Dive and some of our batch capabilities, batch actions. We do charge our paying customers for. Within Everlaw for Good, we provide a free package of AI tokens or credits to Everlaw for Good participating organizations that re-ups every contract year. And so you could rest assured you'd have thousands of dollars worth of AI credits available to you if you were to come onto the program. And then we strive to be a really fast moving program. So if you're interested, you can fill out an application on our website. It takes about 10 minutes to fill out. It's very lightweight. And then we try to turn those applications around and get cases up and running within 1 to 2 weeks, faster if needed. And I think I have one more slide.
Well, shameless plug here as well with
Yeah.
respect to the Everlaw AI credits. Part of what comes with that in terms of the support and training is access to the Value AI team. So if you're still trying to get, your legs under you and figure out how to implement these tools or how to achieve the objective of your case, uh, and how to utilize those credits, we're always happy to help jump on a call and then walk through and talk through live.
Awesome. Thanks, God. Cal's team is, as you can tell, true experts on this stuff, really cutting edge. So, of course, the point of the CLE is to help educate and provide the value to you all. But if you are interested in our Everlaw for Good program, definitely encourage you to check it out and sign up or reach out to us to learn more. So there's a bunch of information on our website, which you can access via this QR code or the URL. And then you can email us at the alias on the screen. That will go directly to me and some other folks on our team. And we can get back to you and share any more information. We occasionally do demos, or we can send over recorded videos so you can get a sense of what the platform looks like. And then it's very easy to get set up. So we'd love to work with any LAC members. So please do reach out if this is something that you could find valuable to your practice and the matters that you're working. With that, unless there are any other questions, I think we can wrap up early and give some time back. You
Goodness.
all, yeah. Thank you all so much for joining. Really excited to have this opportunity, and hopefully you found this useful.